Thank you, Laurel, and welcome everyone. I'm Susheela Varky with Virginia Poverty Law Center, which is the statewide legal aid, and we support all the local legal aids in Virginia. I'm really excited to be moderating today's panel. Next slide, Laurel. I have with us today, that's what Virginia Poverty Law Center does. And this next slide, thank you, Laurel. These are the people who are going to be our experts today. And as I said, I'm excited that they are able to join us. I like that we have geographic representation, a little diversity there. And I'll just let Sherron start and introduce herself, and then we'll get started with our presentation. Sherron?
Hi, I'm Sherron Ashby, and like the slide says, I'm a domestic violence attorney for Blue Ridge Legal Services. Basically, we cover the Shenandoah Valley in the geographic area. I've been doing this for almost 4 years now, and I'm happy to be here, and hopefully we'll be able to give you some information that you'll.
Go ahead, Nora. Nora, you're on mute.
Yep, I got it. Hi, I'm Nora Mahoney. I am the Family Law Practice Group Chair with Legal Services of Northern Virginia. My office is based in Fairfax, but we cover Arlington, Alexandria, Prince William, and Loudoun. I've been with Blue Ridge, or I'm sorry, I was with Blue Ridge Legal Services in their Winchester office for 3 years before that, and I've been with LSNV for 8.5 years.
Thank you. Jamesa?
Hi, everyone. My name is Jamesa Parker. I'm from the Legal Aid Society of Eastern Virginia. We're based in Hampton, Virginia, but we cover Hampton, Newport News, Williamsburg, Gloucester County, Middlesex County, and York County as well. I'm fairly new to this. I'm about 1.5 years in the game. So I've seen a lot and experienced a lot, but I can always see more.
Hi, everybody. I just saw the chat. There's a question about raising the volume. So the person has already raised their volume to 100%. So panelists, do you mind raising your volume on your monitors? And Amy, can you hear me okay? I'm hoping that people can hear me okay. So anyway, let me start our presentation today. Just to recap, and Laurel has already mentioned this, but today is the third in a series of 4 protective order webinars that the Action Alliance is presenting. And part of today is to go over real world protective order enforcement issues with our real world frontline legal aid attorneys who face these issues all the time. So I'm hoping you all will get something, nuggets that will be helpful in how we all are here to support survivors. And another part of this presentation is for you to make connections with us. Relationships are how we can solve problems and help survivors access the services they need. So hopefully that will come from this presentation as well. Next slide. So this slide, how can community and system-based advocates help clients and or legal aid attorneys who are representing them? So we want to talk a little bit about the attorney's role and the advocate's role. So Nora, I'm going to turn this over to you and mute myself.
Sure. So in the work that we do, we collaborate very closely with advocates, and they are immensely helpful in our cases as attorneys. They can be helpful in tracking down clients who have fallen off the map, or alerting us if the client has concerns that they don't feel comfortable bringing to the attorney directly. And so I'm always trying to find ways to better foster that relationship between advocates and our attorneys. We have about 14 family law and domestic violence staff attorneys with legal services. And the thing that is tricky about that relationship between the attorney and the advocate is that even though we both have obligations regarding confidentiality of the client information, the attorney's role is a little different. The attorney actually not only has a duty of confidentiality, but there's also something called privilege. So there are things that could be found out by the other side, by the opposing party, if the advocate is there for that attorney-client meeting, or if the attorney discloses too much information. And so it's really important that the attorney and the advocate always have a VAWA compliant release of information to be able to share the necessary information to coordinate services and making sure the client is fully supported. But it's also, you know, I understand an advocate's role is to number one, believe their client and help them meet their goals and figure out what is going to keep them safe and help them get there. The attorney might, you know, sometimes we have situations where the attorney has information that they've learned in investigating the case that they can't disclose. Like, for example, that the client has also hit the children sometimes, or because an attorney is not a mandated reporter. So, you know, we're trying to advise our clients, and that might mean that an attorney might advise the client in a way that the advocate disagrees with. And it's hard because we can't explain why sometimes. And so part of it involves just building a relationship outside of each case so that you have that level of trust between the attorneys and advocates outside of individual cases. And then just making sure that you have appropriate communication that is approved by the client and that the client understands how the whole system is going to be working together.
Nora, can you talk a little bit about releases and authorization to release documents, information, and sort of the VAWA confidentiality requirements? And Laurel, this would be a good time to share those two handouts on the screen.
Sure. So the Victim Rights Law Center, which is based in, I think, like, it's Boston and I want to say Oregon. They do a lot of national trainings on this. So if you want to know more, I'm going to direct you to look up their trainings. But under the Violence Against Women Act, there are certain requirements for the exchange of information or the disclosure of any information about a victim of domestic violence. And so there are certain requirements. You have to really explain that the client has to put a release in writing that includes what information is going to be released, how it will be released, whether it's by email or fax or telephone or in person, and it has to have an expiration date. And so I think the expiration date needs to be as short as it possibly can. So for example, this is the release that we have at Legal Services. I changed the client's name, but usually mine say, you know, the purpose is almost always to keep my client safe and her children. But usually we'll say, you know, basic facts of the situation and what services the client might need so that we can coordinate our services. We have checkboxes for how we're going to share the information. And then there's a date. I've heard in some trainings that date should be less than 3 months away. That's often not realistic for a custody case, for example. But there is a box at the bottom where you can extend it for more time without having to redo the whole form. And then there's some checkboxes to really make sure the client understands they don't have to release this information. They can revoke it at any time. What I have seen from some places is like checkboxes of places to release the information where an advocate just like drew a line through everything. You really can't do that. The client needs to know exactly what's going to be shared where, and make sure that everybody's on the same page. But also, even as an attorney, even with this release, I can't share and shouldn't share information that's going to hurt my client's case or cause embarrassment to my client or do something harmful to that person.
Thank you. And there is another form that is bilingual that, here we go. And I don't know that Nora needs to go over it, but by the way, these documents will be shared with you all. And I know I've used Nora's documents to update my own releases, and I'm sure she's comfortable with you all doing the same if you would like. So,
And this one is from the Victim Rights Law Center. This is the sample that they hand out.
awesome. So let's move, Laurel, to the next slide, if you don't mind. And while you're doing that, Laurel, I'm just going to shift gears to another one of our panelists to talk about real life examples of how advocates end up helping legal aid attorneys. So Sherron, I'm going to turn the mic over to you.
Sorry, I had to find my face again on the screen. It keeps changing places. So I could just talk about what the advocates in our area do, and I actually find it very helpful if you are advocates at a domestic violence shelter in your area, or you're advocates at Commonwealth Attorney's Office, or some other kind of domestic violence advocate. I implore you to talk to try to set up a relationship with the attorneys in the offices that are nearby, the legal aid offices. Like Nora said, it's very important for us to have a good working relationship. For example, here, our local DV shelters already have electronic copies of Blue Ridge Legal Services applications and questionnaires that they can have clients who are staying with them, or even just clients who walk in, fill out, they fax it to us, we send them through intake, and then if they qualify, they're able to speak to an attorney, and potentially you get representation. I think that's very helpful. They've also been able to help some clients fill out paperwork at the court, like filing petitions for custody or visitation or supports, filing for protective orders, petitions like that. I also think it's particularly important for people who work with who are victim witness advocates, particularly in Commonwealth attorneys' offices. Make sure you keep the victims in your cases updated with what's going on in their case. It's very important to talk to them before the trial of the matter. I know most of you try to do that, and I understand that you have outstanding numbers of cases on your docket, but just taking a little bit of time ahead of schedule to talk to them makes things so much easier to prepare them for what's going to happen today. Am I going to see him today? Can he ask me questions? Can his attorney ask me questions? Asking them what sort of relief they would like to see from this. You know, would they like a judge to maybe order him to take anger management classes, or maybe some mental health counseling, or would they do they believe that jail is appropriate? Would they like a protective order or a no contact order in place? That sort of thing.
Thank you, Sherron. You brought up something that came up in our last presentation last week. So when petitioners are filling out the paperwork to ask for a protective order, they may be checking a number of boxes of the types of relief that they would want. Could you speak, Sherron, and then I'll ask Nora and Jamesa to jump in if they wish, to do you have to, in your jurisdiction, have checked that off already? Or are there times where you, during the hearing for the full protective order, may the petitioner ask for relief that she or he has not asked for on the original petition?
It sort of depends. In our jurisdiction, there have been occasions where, particularly where you're asking for the abuser to pay for utilities or continue paying the rent or the mortgage. It's best if you actually put that on your petition. or if you want possession of the car. There have been times when I've been able to get a judge to grant more relief than what was requested in the petition itself. But the safe bet is to ask for whatever it is that you might need.
Thank you. Nora or Jamesa, do you have anything to add?
I'd say it's hard to get additional relief without, usually what we need to do is we try to file a written motion ahead of time, just putting the respondent on some notice that we might be asking for additional relief, or if that's not possible, making an oral motion to amend it. I think there are some judges who will do what Sherron described, where if, it's things like we've asked for suitable alternative housing and now we're saying we want them to pay the mortgage. I think if you haven't asked for anything other than no contact, no exceptions, it's really hard to get a judge to ask to add the relief. I think it really depends on how different what you're adding is from what was originally asked for.
Thank you.
Yes, I'd agree with Nora and Sherron. Usually, if you don't petition for it in the beginning, the judge is a bit hesitant to provide that relief to you unless there are, extenuating circumstances that will, I guess, they find valid for them to extend that out. And as Sherron said, I have had some judges grant more relief than what was petitioned for, just based on the facts that came out during the hearing.
Thank you. Laurel, you can go to the next slide. This is something that we wanted to make sure we talked about, especially as we talk about the advocate's role versus the attorney's role. So advocates are really helpful in helping survivors deal with trauma, all types of trauma. And Jamesa, I'm just going to turn it back to you to talk a little bit about your experiences and how that went for you.
So in my experience so far, I've had a lot of clients that tend to block out what has happened to them while it's happening, and sometimes a little bit afterwards, because they're kind of still in shock and disbelief that, the person that they trusted so much could do something of this sort to them. And so once they reflect and realize what all is going on, it can really take a toll on their mental health. And so I found that we have some good advocates that will set them up with, programs that are around depending on the area and what's available to them. Some of them will set them up with the Community Services Board, and there's other outside programs like Chesapeake Counseling, or there's a program called Transitions that helps specifically with people who've been victims of domestic violence. And yeah, so that helps them with that. They'll also provide them with family counseling and sometimes mental health assessments if needed, based on what comes out during their therapy sessions. If the petition is granted for most of the persons seeking the petition, they do feel relieved that they got that, they feel vindicated that their concerns were heard and that they were valid. However, some of them still kind of feel afraid based on how much trauma, how long, and how intense the trauma and abuse was, that they feel that the abuser will come back for some reason or another and try to hurt them. And some of them actually feel guilt or feel bad for the abuser because now it's on their record and it may affect their employment and things of that nature. If the petition is denied, however, a lot of clients feel as if they did something wrong, the judge doesn't believe them, it wasn't valid, and they feel as if sometimes the court, and I'm not saying that this is what it is, but I've had some clients express to me that it's almost as if they have to almost die in order to get some type of relief or be protected. And so that's how they end up, getting set up with therapy and everything like that. They're trying to help them process that. It also takes a toll financially, physically on the person, depending on what they went through. Some people get sad looking at pictures of themselves. because of I guess the bruises and other residual things that happen. I have a client where all her teeth were broken and she's having to get dental reconstructive surgery, and just having to go through that, which also then contributes to physical trauma because people will try to get these things fixed through cosmetic surgeries and other things. And outside of just cosmetic surgeries, financially, it takes a toll on people, especially those that are married. When you're living together, you're splitting the bills, or, you know, maybe that person, it could be, you know, your husband is I hate to say breadwinner, but they're the primary financial person in the home. And so having to be left to pay all those bills, it can cause like financial problems for you. And it's just tough sometimes because some clients almost find it crippling and hard to, I guess, pursue the protective order because they're in a position where they need the money. They don't have another way to get the money. And they feel like, well, if I just drop it and try to be good or not set them off, then, you know, it won't happen again and we can just move along. And it also kind of doesn't help that there are kind of limitations in a sense, because as we stated before, if it's not petitioned for, they might not know at that time to ask like, hey, I need financial assistance. And if they don't know that, they might just ask not to be contacted, but they still have to pay a mortgage. They still have to pay light bill, electric, gas bill, things like that. So statutorily, it doesn't require them to pay it, again, if it's not petitioned for, but it does leave it to a point where it's like, hey, you can't terminate this, you can't cancel this. So you do have that at least to protect you. And also, in addition to bills, we have jointly titled vehicles sometimes, and sometimes we don't. The person that you're petitioning against, the respondent in some cases may have all the cars in their name, but you know for a fact this is your car, you've always driven it, but it's not jointly titled or even in your name. So the court can't necessarily give you access to a vehicle that's legally technically not yours. So that can become a problem. And it also requires, like we were talking about the utilities, that they not cancel them, but it gets to a point where if they build up for so long, if the protective order keeps getting continued, then you may not be able, by default, is going to be terminated, which at that point you can file a show cause and make them, you know, at least pay the minimum to get it back on. But it's still not, I guess, a full relief as to how you're financially going to support yourself if you decide to do something about, you know, the abuse that you're enduring. And I guess to cycle back to mental and emotional trauma, sometimes family and friends aren't the most helpful in these situations and not the most supportive, because some people just think that money, you know, produces all happiness. They sometimes say, oh, well, he's a good man, like equating good man with he has a lot of money and he takes care of you that way. But you're breaking me down emotionally, physically, and elsewise. And so it just becomes a issue where you can't really discuss these things with family or friends because they make you feel bad for taking out the protective order, or they deny that those things happen to you and say that you're exaggerating. So overall, like having advocates there to help the petitioners get public assistance, get some food stamps, you know, get therapy for them as well as their kids if they witness it, is very beneficial in the long run and helping us getting our part done.
Thank you, Jamesa. Next slides, Laurel. I wanted to segue into this slide and talk about some clarifications from our last training last week. And one thing I wanted to talk about, especially because you just mentioned it, Jamesa, the statute says that the judge can order temporary exclusive possession of a car that is solely titled in the petitioner's name to the petitioner, or jointly titled, temporary exclusive possession. There's also, I'll get to you in a second, Nora. My question really is, have you ever been able to get a car that is solely titled in the respondent's name to the victim through the catch-all relief in the protective order, and I'll mute myself. Go ahead.
I would like to jump in. So it doesn't say jointly titled, it says jointly owned. And so it's rare, and I think for most of the state, most judges read those as the same thing. We have on rare and exceptional occasion in some of our Northern Virginia jurisdictions successfully argued that the legislature chose the word owned instead of titled for a reason. And so if the parties are married, and that vehicle was purchased during the marriage, it is jointly owned by the parties, even though it might be titled to one person or the other. And so the court can grant exclusive possession of that vehicle, but it's a hard sell.
Thank you. Anyone else?
Yes, actually, I didn't realize that I didn't realize the wording of the protective order itself until just now. I've had judges give people exclusive possession or use of cars that were titled only in the respondent's name more times than I can count. I'm going to, because it works out for my clients, but yeah, I have not had any problems to let some vehicle, even if it is in someone else's, like someone owned by someone else.
Sherron, you're kind of breaking up a little bit for me and freezing. I don't know if there's anything you can do about that. I just wanted to let you know. Let me move on to these other clarifications. So I think we talked about this last week. Parents may get preliminary protective orders or ask for a full protective order against a minor child, but they cannot do that against, get an EPO against a minor child. And then these other topics, mortgage relief, this came up last week. Mortgage relief for the petitioner. The judge doesn't have jurisdiction over, BB&T or whoever holds the mortgage, right? But I'll let the panelists talk about how they've been able to get actual mortgage relief for petitioners through the protective orders. Sure, I guess, Jamesa, do you want to start?
Sure. So it's been as much as, and it could be just maybe emotional guilt, but I had a 74-year-old client who had been married to her husband for about 34 years. He paid all of the bills in that nature, and just being able to, I guess, have her tell her story and the way she was emotionally affected by everything that was going on, the judge went ahead and added, you got to maintain the mortgage. She gets her car and everything like that. So it depends, I believe, on the judge and their willingness to listen, because a lot of judges like, okay, what happened this day? They're very stark on a timeline. If it doesn't go directly to that incident and specifically, then they just don't pay it any attention. But being able to have her tell her story helped with that, at least getting that out.
Nora or Sherron?
I'd agree. I think, this is one of those places where you need to have some kind of notice to the respondent that you are going to be asking for the payment of housing costs. But I think the judge can certainly order that the respondent continue to pay the mortgage. We've had that in the past. It's really no different than suitable alternative housing. It's just not alternative.
Right. And Sherron, do you have anything to add?
Absolutely. I think as long as it's in the petition, I imagine that's enough notice, or at least our judges around here have found that that's enough notice for the respondent to know what's being requested. And also, if they got the preliminary protective order, it would say that he was to not terminate utilities, or he was to continue paying the mortgage, or something to that effect. It, particularly in a situation where parties are married, there are children involved, and the abuser's been the primary breadwinner financially, a judge is not going to kick a woman and her children out of the house because her husband is being a tool, for lack of a better word. So they understand that there are other aspects to protective orders than just do not commit further acts of abuse or injury to property against this person.
Thank you, Sherron. And this last item, JDR, Juvenile and Domestic Relations District Courts and General District Courts, Caitlin last week talked about how they're not courts of record. And we just wanted to clarify what that means, like what the definition of that is, and also address confidentiality issues. So Sherron, I'll ask you to speak to that.
All right, so basically a court not of record doesn't by itself mean that everything that happens in the courtroom is confidential. For example, general district courts are courts not of record. Anybody who wants to can walk right into a general district courtroom and see what's going on in court, as long as they're not a nuisance to anyone else. Basically, what courts not of record means is that there isn't already a court reporter there transcribing everything that happens to make sure you preserve a record for an appeal later on. In cases where you would like to have a court reporter there, I filed a motion asking for a court reporter to be present, or even ask the judge, do I have permission to record this protective order hearing or whatever hearing for later use? I've never had a judge say no yet. And then the confidential part only applies to cases involving juveniles when they're like custody cases involving juveniles, or cases where juveniles have been charged with crimes. Those are actually considered confidential, but your cases between two adults, like a protective order between a husband and his wife, those are not confidential. Those are they just happen to be in a court not of record.
Thank you. Nora or Jamesa, do you want to add anything, or we can move on if you don't?
I would just add that I think it was actually a rule change several years ago that actually said that you are allowed to record by any device you have in JDR. And so it's become very common in our courts that either we or the respondent, if they know that there's a good chance you might appeal it to circuit court, I've even had, that somebody will come in with their cell phone and ask to record. I've even had the public defender, where there were criminal charges pending as well. The public defender has come in with the cell phone and say, I'm not representing the respondent, but he's going to use my phone to record this hearing. And I've recorded hearings for the prosecutor as well.
I just add that I've never actually experienced any of that in any of the Peninsula courts. Of course, I've never requested, because I didn't know that was a thing, to have it recorded, but I've never seen opposing counsel in any of the different localities request that. So I find that to be very interesting, and will definitely be utilizing that going forward. And I can also say, for the juvenile part of it being confidential, even though it's supposed to be confidential, depending on what court you're in, and if it's an open arena, unless the judge specifically asks that you leave, because some courts of JDR, you can still come in and watch no matter what it is. I guess that kind of then goes with the confidentiality, depending on the setup of the court.
Right. Okay, moving on to the next slide. So, some real-world protective order enforcement issues. The whole incident deriving from, in other words, one incident can mean a civil proceeding, protective orders, or a criminal proceeding, and going over that process. So Nora, I'm going to ask you to speak to that.
Sure, I should maybe just leave myself unmuted. But it's hard for people who are not already kind of embroiled in the legal justice system to understand the difference between criminal and civil matters. For a lawyer, it's kind of second nature, but it really is confusing from the outside. A criminal matter is that somebody has committed a crime. And those cases are captioned Commonwealth of Virginia versus John Doe. And those cases are the state prosecuting somebody because they have done something that, for whatever reason, the legislature has decided should be a crime. Those are the cases that have, the possibility of jail time. Usually, there are some exceptions, but usually, criminal means possibility of jail time. Civil means no, it's usually going to be money or something else that we're trying to decide. Civil matters are petitioner versus respondent. And that is Jane Doe versus John Doe. And so I usually will back up and explain this to my clients, because a lot of times my client doesn't understand what happened. They called the police were there, they gave her a piece of paper that they said was a protective order that would keep him away for 3 days, and then she found out that there's a court date to go file for a protective order, and there's a court date that she has to come back for the protective order, and there's a criminal court date, and doesn't know what's going on. What's important for my clients to understand is that they don't control the criminal matter. The prosecutor is required under the Crime Victim Rights Act to consult with the victim and find out what the victim wants to do or what the victim would like to see happen. But they can decide to prosecute even without the victim if they decide that's really what's best. With a civil protective order, the petitioner controls that case, and the petitioner can decide to make the whole thing go away if this is all getting too stressful. The petitioner can decide that even though it's a bad case, they really want to go forward with it and really want to try to say their piece in front of a judge. They are the ones who control that case. And the result in a protective order case is going to be a protective order, but other civil cases might be a custody case or a divorce, child support, a landlord-tenant issue, what's called a warrant in detenue, where if somebody has your belongings, you can get your belongings back. Sometimes we've had to do that where the parties aren't married and the respondent is hoarding all of my client's stuff. So it's important for clients to understand that the civil matter, which is the protective order, usually referring to the protective order matter, is under their control. And these are decisions that they can make. And so when I'm doing options counseling with them about how to proceed with a case, I always make sure that dismissing the whole case, non-suiting it, is always an option. It's often a bad option. It's often not something they remotely want to do, but it's always important to make sure that they understand that that's out there. Do you want me to speak to the second point about the process in my jurisdiction as well? So I mostly practice in Fairfax, and I'm also most familiar around here with the Alexandria process. I don't know how much of Virginia has implemented the LAP, the Lethality Assessment Protocol. I understand many jurisdictions across Virginia are using it now, but Fairfax, Loudoun, and I think Arlington and Alexandria are starting as well. But I know in Fairfax the best. They are using the Maryland model, where when law enforcement is called out to the scene, when they assess who the real victim is, they're going to pull that victim aside and have a confidential conversation with them, and they go through a checklist of the key lethality protocols or indicators. That's what I'm looking for. And if the client scores high on the lethality indicators, or if the officer just has a gut feeling that there's been abuse here that's pretty severe, they all have special cell phones with them that they can connect to an emergency hotline and speak directly to an advocate right away. And then the advocate will usually make the referral to us, to legal services, or to somewhere else. We have in Fairfax a really successful program with the court, where when someone goes to JNBR intake to file for a protective order, they're given a packet of paperwork to fill out, but the application for our services is part of that packet. And so they automatically, they get information about what it is, but if they fill that out, then the intake officer includes a release of information And the intake officer then scans all that paperwork together along with the preliminary protective order and sends that to our organization, actually uploads it directly to our server. And then we reach out to the client to schedule them with an attorney. And we have volunteer attorneys who sign up to cover cases every day of the year. So, or staff attorneys. And that has been really successful because often petitioners will get that preliminary protective order for 2 weeks and think, oh, okay, now I have to deal with housing and I have to get my kid in school and I have to do all this other stuff. And they don't think about the court hearing until 2 days ahead of time, and then they can't get a lawyer. And this way they're connected with a lawyer, usually within a day or two of filing. And then that lawyer has the time to gather the evidence that they're going to need and put on a better case. We call it our Attorney of the Day program.
Thank you, Nora. Sherron or Jamesa, do you have any other items to add?
No.
All right, cool.
I would like to add one thing for those of you who are helping people that try to get protective orders. That the attorney that is going to be the Commonwealth attorney, and that it makes sure they understand it's very important to keep the Commonwealth Attorney's Office aware of their contact information so that their criminal case doesn't fall through the cracks.
Thank you. And would you three say that when there is a criminal case, companion criminal case from the same incident that your client is trying to get a protective order for, that maybe they've gotten the preliminary protective order and the courts tend to hold the arraignment and try to continue the preliminary protective order to have the full protective order hearing after there's a disposition about the criminal case, or does it depend?
It really depends by jurisdiction. In some of our jurisdictions, the judge will usually continue the protective order case to either be heard at the same time as the criminal case or, right around the same time. In Fairfax, that pretty much never happens. The judges believe that those are two separate cases. They have different standards, and the judge is looking for different things in those cases, and so they should be completely separate. So sometimes the protective order will get continued until after the criminal case, but if the charges are severe, what's more likely to happen is that the public defender or the criminal defense attorney will ask to go forward on the protective order right away before the victim has had a chance to get, say, all of the pictures from law enforcement, didn't have a chance to subpoena the officer, don't have the forensic reports from, for the strangulation or whatever it was, go forward, cross-examine the snot out of the victim so that the victim doesn't know which way is up, let the protective order get entered, let it then immediately appeal it to circuit court, and then use the recorded transcript of the victim's testimony against her in the criminal trial, or try to use it to negotiate with the prosecutor. And so there are cases where, for whatever reason, we non-suit the protective order so they can't do that. And then we file again when we need to, and that requires a lot of coordination, but sometimes it's the right move.
I say for the most part here is, like Nora said, either the same day or is about the same time. However, some jurisdictions will still require you, instead of using the testimony that was presented in the criminal, they still may require you to go through a full trial, which is pretty duplicative, but it depends on that judge. And I've also seen it where a defendant has just willingly wanted to go through with respondent has wanted to go through with the protective order hearing and wasn't concerned with his Fifth Amendment right. So that's the only time I've gotten to do a protective order before having the criminal charges done, which I think is helpful because it's a higher burden for the criminal. So it's more than likely if you're found guilty for that, then the preponderance of the evidence is pretty easy standard to meet.
Exactly. Thank you. Next slide, Laurel. Modifications. So what types of modifications are you seeing being requested in your areas? And sort of, I guess I'll ask Sherron and then Nora and Jamesa to speak to that, and then we can go to the next question.
Modifications generally I see here actually can be filed by the respondent or the respondent's attorney or by your client. Like the client might have a preliminary protective order or a protective order that says they can't have any contact whatsoever. And then she's, oh crap, we have 3 children and we need to have visitation. So can we change that to, you know, electronic contact visitation for the children? Usually those are the sorts of modifications that I see is can we modify or how contact takes effect. On occasion, the attorney file a motion to modify the protective order saying he wants to get back into his house or what have you.
Yes, Sherron, I think we may have just lost you. I'm going to shift to Nora until you come back. And when you do come back, I know there are maybe connectivity issues, but just speak louder too.
Sure. So what the modifications, like Sherron was saying, I think the modifications we see most are around the contact permitted between the parties. That's usually the biggest issue. I try to head that off in the beginning by training our attorneys and our volunteers that if the parties have kids together, they probably are going to need to communicate at some point somehow, whether it's through a third party or in writing. And it's usually better to make that exception right from the beginning so that it's clear right from the beginning and you avoid violations and confusion. And I usually make sure, I don't think it's a good idea for people to talk on the phone because it's too easy for things to escalate that way. Keep it in writing, text messages, our family wizard, something like that. The thing that I will often see a modification for is, you know, there's a permission or there's permitted communication by text message about the children. And then the child has an asthma attack and is in the emergency room and mom really wants dad to be able to be there, or the child has some kind of severe medical emergency and they want dad there. And a lot of my clients will think that they need to drop the whole protective order in order for that to happen. And so it's always important to remember, like, just tweak it, just modify the language, carve out a little bit more contact and it's okay. I think in terms of some of the questions you asked, Susheela, I don't think judges are really requiring much evidence in hearing a modification other than, you know, do the parties agree or not on this modification? And if it's what the petitioner is asking for, they will usually grant it, but not always. And then also, you know, is it necessary? Is this a modification that's necessary to protect health and safety? I would just note that if it's a civil protective order that was issued as part of a sentence for a criminal case, like there was an assault and battery charge and the prosecutor got a protective order as part of that criminal disposition, the prosecutor has to be involved in any modification of that order. And I think that gets people a lot of time because they get in front of the judge and then they realize they need to bring the prosecutor in to get their permission and their sign off as well.
I have had a respondent request to modify the order, and it was, I don't want to say strange because it makes sense, but it was for employment purposes. All of his tools were at the marital home, and he wanted access between these hours every day. And I of course objected, and client was not willing to do that. And the judge said that was inappropriate as well based on what was going on. So I've had employment exceptions requests come up. I've also potentially had it where they decide during the PO, hey, you know, let's just end this. And for divorce purposes, I've seen modifications for, you know, like maybe having written communication for disposition of property and assets, or potentially having a third party, a neutral third party come and have that, or have them deal with it that way. Like Nora said, I really haven't seen much evidence required, especially if it's on the petitioner's behalf. The respondent seems to get more of the third degree if modifications outside of what the petitioner has requested is asked for.
I wanted to just interject. There's a question in the chat that I thought we could answer now. So the question is, what if your judge says to the petitioner, well, you don't need a protective order, you're communicating with the respondent about the kids that you have in common, so clearly you're not afraid of the respondent. Can maybe Sherron, if you're back on, can you respond? And then Nora and Jamesa, if you have anything to add.
In that sort of situation, I mentally bite my tongue and, you know, refrain from saying what I believe, and just say, Judge, this communication regarding the children is about what's in the best interest of the children. The protective order is about what's safest for the client. And it's not at all unusual to have a traumatized or victimized mother say, well, regardless of my safety, I understand that he's their father. He needs to be a part of their lives. And we need to have some sort of communication. That I imagine that that's something that you could see in certain courts. I don't think I've personally seen it in mine, but I've had some other tongue biting moments where you just have to take a step back, don't say what you're really thinking, and try to give a logical explanation to the judge of why she can actually be afraid of him, but still need to have contact with him for the children's sake.
Yeah, I'd say the same, and just say that, and I'm assuming this is a scenario where there's a preliminary protective order, the protective order is pending, and the petitioner is communicating about the children. And you know, that makes it harder to get the final protective order, because it's a violation of, I mean, it's inviting a violation, right? The petitioner can't violate the protective order, but it's inviting him to respond and violate the protective order. And so that does make the case more challenging. But I think there's a line to be drawn. The protective order is to protect her health and safety. Presumably communicating about the needs of their children shouldn't affect her health and safety. Seeing him in person and letting him talk about other things like how much he hates her and how he wants to kill her, that would endanger her health and safety, and draw that distinction.
I completely agree with Sherron and Nora. I have had a judge do that to me, total tongue biting moment. But as Sherron stated, I make the same, you know, best interests of the child argument, because if she does withhold the children, then that could be used against her in potential and upcoming custody and visitation matters. So after that, then he kind of came around and he went ahead and left it alone.
Thank you. Next slide. So given where we are, you know, end of September during this pandemic, I wanted each of you to talk about some of what is happening in terms of procedures during COVID. So Sherron, I'll start with you, and just, you don't have to answer every one of these questions, because I didn't say this at the beginning, but I do want to set aside time at the end for your all's questions, burning questions you've had all along, or things that come up during this training. So Sherron, I'll turn the mic over to you to respond.
In our jurisdictions or different judicial districts, I guess dealing with COVID has been a very ad hoc basis. It depends mostly, it can depend on the day of the week that you go to the court. It can depend on the particular judge that you have. It could depend on what kind of mood you have the particular judge in on the day of a hearing. But the best bet for finding out, you know, what's required when you come to court: do you have to get your temperature taken? Must you have a mask? Can you participate by phone or through some sort of a video Zoom type medium or platform? Is to contact the clerk's office before the hearing to make sure that you're doing what you need for your client to participate. Does the court require that you file a motion for someone to participate by telephone or via a webcam? Or can you just say, Judge, this person has COVID, you know, can we just have them testify by phone when you go to court? It's all very, it depends very much on the jurisdiction, because there are no set guidelines since we've never been through something like this before.
My turn? Okay. So our jurisdictions are all doing something completely different. On one extreme, you have Prince William, where nothing is remote. And then, you know, Fairfax, everything is remote, and how that is happening and how that plays out with protective orders, I think does affect things. We have some judges in Fairfax who, because they're hearing the case remotely, they don't get that palpable sense of how afraid the client is. And so the judges are ruling maybe a little bit differently than they would in the courtroom, just in terms of us preparing our case and kind of guessing how this judge is going to look at the case. We've also had situations where I was remote with my client, or one of my attorneys was remote with her client, and this has happened multiple times, where the respondent showed up in person and started acting out, and where it was not that strong a case, but my client was safe in her own home and was able to testify better than if she'd been in the courtroom with the respondent staring at her. And the respondent just felt powerless because he can't really see her, and he's acting a fool, and the judge was much quicker to grant a protective order. So it can kind of cut both ways. But otherwise, I think things are pretty much the same. I think it's been harder to get things enforced by law enforcement. I think they're much more reluctant to go out and to engage with a domestic call at all. And that's because of COVID, and I suspect it's also because of a variety of other things going on in the world. And we are absolutely seeing abusers use COVID as a threat to the survivor, less a threat of infection. Like we had one who, where the client became sick, and the respondent used that against her and tried to prevent her from receiving medical care as a way of controlling her, and withheld medical care because of it. And I haven't seen a case yet where judges were considering whether the risk of COVID transmission was a sufficient threat of physical harm. But we have seen in the past judges considering maybe not something as infectious as COVID, but like infection with a sexually transmitted disease was considered a threat or considered bodily harm. So I would imagine a judge in the right circumstances would look at it that way. Not all the judges, but some. I don't think the judges have inadvertently raised the standard in some of our courts, but I think they probably have in others. And do you want me to keep going? The time, this is sort of a very different question, but the timeline for abuse, how recent for recent abuse. So I just want to remind everybody, the word recent is only in the preliminary protective order statute. It is not in the final protective order statute. And so in terms of family abuse, in order to get that preliminary protective order, yeah, it probably does need to be recent, but for a final protective order, and the court really should not be dismissing the whole case if the preliminary protective order is denied. That still needs to be set for a hearing. But I know a lot of jurisdictions don't do it that way. They just dismiss the whole case out of hand. But if, in terms of recent abuse for preliminary protective orders, it needs to be pretty recent. And for a final protective order, the judge needs to find that there has been some act of family abuse, any act of family abuse. But then you also have to show that it's necessary to protect the health and safety. And so if there's been a long gap in time, then you're not going to be able to show that it's necessary. But we had a case recently where the abuse happened in the beginning of May and there wasn't a protective order hearing until July. She didn't file until the end of June, and that was kind of pushing the limit, but it got there. It really varies by jurisdiction. We have some jurisdictions where if it's more than 36 hours, they think you're not really afraid, you can't possibly be afraid. And then other jurisdictions where it might be months, and it's, as long as you can explain why and how, why is there a delay? What happened now? Or what's happening now that made you go and file? And the right answer is usually not, I consulted with an attorney and the attorney said I'd get the upper hand in a divorce. That's not a good answer. Yeah, I think the recent, but I will say, because of COVID, some of our judges have been a little more flexible on the recency question because it's just harder for people to get to court and it's harder to get that paperwork filled out. I have had cases where I was surprised. I'm like, why did you wait 2 weeks? And she's like, well, by the time they sent me the paperwork and I filled it out and then I had to get back, just getting everything done is taking a little bit longer in COVID times.
Jamesa?
I actually haven't had any judges be any more or less reluctant about granting POs. No respondents have used the potential transmission of COVID as a defense or any way to try to avoid getting the PO against them. The 6 months, usually, even though statutorily, as she said, in the full 2-year protective order, it should be based on any, which I'll usually try to ask a catch-all question like, have you experienced, any violence throughout, your time with this person or while y'all live together, something like that. But it's usually the court or the judge will narrow it down to like 6 months, and some of them are very even hesitant to do it that far back. But yeah, I haven't really experienced any people trying to use COVID as a reason not to grant a petition or protective order.
Thank you, Jamesa. And I see a couple of questions in the chat. I wanted to say that we will be getting to the extension question, just so hold on before we get there. And I'm responding this question about what evidence is needed to make sure someone gets their 2-year protective order. I'm not exactly sure what you mean by that. The standard is by a preponderance of the evidence that the judge believes the petitioner over the respondent. And you have to show that an act of violence, force, or threat happened that resulted in bodily injury or fear of bodily injury, criminal sexual assault, or death. So I think Nora mentioned this earlier today, that there's this sense that the injury needs to have happened plus fear to get that full protective order. And I think there was one other question about, police not actually serving protective orders. And I'm sure that can be even more of an issue during COVID. So let me stop talking, and if Sherron, Nora, or Jamesa want to speak, that would be great.
The getting a protective order served on somebody, what I usually do is just hound the sheriff's office. I just, have you served him yet? Have you served him yet? Have you served him yet? Just make sure that they know that, this is where he's going to be today. Like he's working today at, at Pilgrim's Pride chicken plants or whatever, just to let them know that's where he's going to be and just try to make sure that he does get served.
I'd say this is one of those places where the strength of your coordinated community response and your relationship with the Sheriff's Department really can make a difference. Where, you know, bring the Sheriff's Department into the coordinated community response, make them part of the team, get them on board, develop that relationship so that you can just call them up and say, hey, I just got some new information about where he might be, and work with them. It's harder when it's a jurisdiction that's, you know, outside of your normal purview. And you know, the bottom line is, in the end, the client could always hire a private process server. It's just usually for our clients, that's cost prohibitive.
Usually when we get the protective order on our end, it's either a referral from another surrounding, I'd say, organization, or the client has already gone and taken it out. The police were there, they were served there in jail or on site, so they knew not to contact them. So I have not had to track down someone with the sheriff's office. And if there has been a instance where they did not know where they were, the court actually had the sheriff's office go out. They ordered them to go, you know, put out a capias or whatever out on them, even if they hadn't been served before. So I actually haven't experienced having to track anyone down for petitioners.
All right, in the interest of time, I'm going to ask Laurel to skip over the next slide, which is about process and procedure. And this is perfect, Laurel, thank you. So I think the idea is that processes and procedures, especially during COVID, are really very different in different courts, different jurisdictions, as Sherron said, depending on the day or the judge. So all the more important for you all to have relationships with each other so you can figure these things out and share information. Moving on to technology. Technology, as you all know, can be very helpful in you know, demonstrating evidence of contact for a violation purpose or something like that, but it can also be a way that a tool that abusers are using to harass and manipulate and harm victims. So I'd like you all to talk a little bit about sort of the good and the bad about technology in serving domestic violence victims and in the types of abuse they're experiencing. So I'll ask Sherron to start.
Yes. So a lot of times technology is definitely going to be running apace with the legislature or ahead of the legislature, and happily General Assembly in Virginia has kept in touch with some of that. They've made sure that they've added amendments to the statutes for protective orders that you can say he's not allowed to use a family tracker. Like if you have a family cell phone plan, he's not allowed to, for lack of a better word, or he's not allowed to cut off your ability to have cell phones or to use them, because that is obviously something that abusers will do anything they can to alienate their victim from being able to get help. I've had a number of cases where the abusers are either using cell phones or trackers or even GPS locators on vehicles to track a client, not physically following her, but monitoring her movements and texting. Why are you there? You told me you were going to work, or you told me you were going to the grocery store, but you're on 81 or something like that. They definitely evolve, I guess, for lack of a better word, along with the advancements in technology, which is unfortunate, but hopefully we'll be able to keep a pace with the technology as time goes on.
Nora?
We see exactly what Sherron described. We see that all the time. The other thing that we're starting to see more of is people manipulating smart home devices. I had a client fairly recently whose husband left and wouldn't tell her the passcode for the Nest thermostat. And so it was summertime and he turned the thermostat up to like 88 or something like that. And then in the wintertime turned it way, way down. Like, and she couldn't do anything about it. And so I worry about things like that. The other way that we see use of technology just exploding is the evidence in cases. People are just using their cell phones to record absolutely everything. Hours and hours of arguments between the parties where the phone was between the seat cushions or in somebody's back pocket, and it's sometimes fascinating and sometimes just painful to listen to. Painfully dull, not painfully like physically painful. And other times it's really useful evidence, and it's hard to know. And it's also important that advocates and clients know that once litigation has started, your client can't delete any of that stuff. The client, any party, that could be evidence, and so it would count as destroying evidence if they start deleting photos, deleting audio recordings and messages. And so that can be just a real burden to find enough room on your phone and to back all of that up. I know that there are some new apps that, yeah, I think I see it in the chat that somebody's mentioning the new NNEDV's new app. And I have it on my phone. I haven't played with it yet, but I think it's a great opportunity for people to make sure that they are able to store their evidence, because we also see, especially when there's like a shared iCloud or people share passwords, I've seen a lot of respondents who go in as soon as they get served with that protective order and delete all the videos and try to delete all of the pictures of bruises and stuff. And the client's like, it was there and now it's gone. So it just gets really, really tricky, and it's hard for lawyers to keep up, and the legislature is way, way behind. So we just do the best we can.
So I definitely say that technology has advanced and that purpose for, tracking people. I've had clients have to switch their numbers and all sorts of things because the respondent is still, they're on the same plan, still tracking them, who they're talking to, telling their children, hey, mommy was talking to XYZ, who is this, who is that, things like that. And so it really has become a problem in, I guess, security purposes for the petitioner in some instances, but in other times, where like you have police enforcement come in and stop that, if they tell them like, hey, we have this tracker, and violations come up that way. I've seen it. In terms of evidence, I can say it's been really helpful. Screenshotting can really be detrimental to a respondent who likes to be mouthy on Facebook. So that's helped me in quite a few instances. Recordings have helped as well. Sometimes the only problem that I have come across with technology is sometimes the authenticity of it, because there's so many like text mobile apps, and people can, recreate conversations with themselves, like using like Google Voice, like that has one number. And then they're like, oh, well, the petitioner used to have this number, or XYZ, or the respondent, because I've had a client where it was a mom and dad, I can't say kidnapped because there wasn't a custody order, but he took kid out of school from from Newport News, took him to Virginia Beach, and then submitted all these fake text messages between him and my client saying how she was going to kill their son, and then had CPS, take away her parental rights and put in like a PO through CPS, and then filed one on behalf of his son through the courts using fake text messages. So yeah, it's crazy. And then the court was like, well, there's no way to prove, if it's her or not, even though she had a whole different number. But either way, technology can be helpful in evidentiary purposes. And unlike the one with most recently with my other client, it was not helpful.
All right, Laurel, would you mind moving to slide 15 about extensions? All right, ladies, I'm going to start with Sherron and just respond to any or all of these questions. How much evidence is needed to get an extension? It says permanent, the 2-year protective order. Is one violation enough? Do you need more? Does it have to be recent contact? And what is recent in your experience?
So this is a difficult one to talk about because there's definitely a provision for you to get an extension of a full protective order in order to get that. So it's left to judge's discretion. A really good thing or a really bad thing depending on the circumstances. Personally, I feel like you would need some sort of evidence of violations or continued abuse for a judge to be willing to continue a protective order out for an additional period of time. Just based on my experiences with our judges here, but what is necessary is very unclear.
So this is a challenge, and we ask our judges this question at every opportunity. In fact, we had a meeting with judges, kind of a meet and greet thing on Monday, and one of the attorneys asked about this, and we never get the same answer twice. And every judge has their own answer because the statute is very vague on this point, and as Susheela will tell you, it's deliberately vague. So all that you need to show is that the protective order is still necessary to protect the victim's health and safety. And so technically you don't need a new act of violence, force, or threat. You shouldn't need a violation. And so there is no hard and fast rule. Every judge is going to look at it differently. Some judges are more willing. I know the Loudoun judges are much more willing to grant an extension. And then there are others like I would say in like Prince William or Arlington, they're probably not going to grant it. The clearest articulation of a standard that I particularly like comes from Judge Mann, who is one of our circuit court judges who used to be in JNDR. And he said he'll grant an extension if either the original act of violence, force, or threat was so severe that he wished he would have granted it for more than 2 years if he could have, or if the respondent has done something. It doesn't have to be a full violation. It could be just like tiptoeing up to the line and not quite crossing it, done some kind of actions or said something that makes the petitioner reasonably afraid that something's going to happen in the future. Other judges want to see that there is a violation, but then I had a judge say, well, if there was a violation, then she should have filed criminal charges. And I said, she didn't want him to go to jail. She just wanted a protective order, and he still said no. So it really, really varies. I think that one of the strongest ways I've also argued for it was that I had my client's therapist testify or be ready to testify that my client was still so traumatized from the original event that it would set her back in her recovery. She was really suffered a traumatic brain injury and had severe PTSD. And so having that protective order in place was really essential to her becoming a functional person who could do work again. And so that was successful as well.
Thank you. Jamesa, anything to add?
I just add that it maybe depends on if there were criminal charges associated, because I know if there may be potentially still in jail, or if they received on their, bond or whatever, like you are strictly to have no contact with this person. Some judges may find it a bit duplicative to continue the protective order if they've been, advised criminally that they can't have contact, or it'll put them, back in jail, or they'll have a probation violation. So that's when I think the burden gets a little bit harder depending on the standard for that. But other than that, like they said, it's kind of vague, and it just is, I think it's a case by case circumstance.
Thank you, Jamesa. I see a question in the chat, which I think makes it a good time to go to our slide that says question everything. So one thing I wanted to mention in response to this chat question and the discussion we were just having, depending on the type of violation of the protective order, it can be something that's immediately arrestable, which is going or remaining upon the land, buildings, or premises, further acts of family abuse, committing a criminal offense, or contact by the respondent with the petitioner or family members. So those are the three types that you can get an officer to arrest someone for that violation. Otherwise, you may have to ask for a show cause hearing. And I think that's a discussion for another day. And I will just mention one thing in this discussion about the evidence for an extension. One of you all mentioned that if it's a particularly violent act that led to the original protective order being issued, I think it was Nora, that judges are going to be more likely to grant that extension for 2 years. As of this year, there is a new law that victims of certain types of violent felonies can ask for, and this would be at the circuit court level when the judge is during the conviction of that felony or during sentencing, Commonwealth's attorney or a victim can ask for up to a lifetime of the defendant length of protective order. So, and I can send you guys information on that. I'd actually like to hear from you how that is working and if people are using that and asking for that. So that's a new option. And I will stop now. If any of you have any questions, I'm sorry we only have 2 minutes left officially on this webinar. But do you guys have questions that you want to ask or put in the chat? And I'll stop talking.
I can answer. There's one about the new law and the protective order. So there would always be something in as part of the sentencing order. Like I had a client years ago who, as part of the sentencing order, the defendant wasn't allowed contact with her for 42 years. But the idea of this law is that it is in the form of a general district court protective order under 19.2. So it's an order that she can take to a different jurisdiction and they'll know what it means, as opposed to having to reach back out to the prosecutor and deal with law enforcement in the original jurisdiction to get that bond revoked. Revoke their probation, not bond.
Thank you, Nora. Any other questions, or Sherron or Jamesa, anything you want to add? Thank you, Jonathan. You rock, my General Assembly husband. Thank you for putting that in the chat. That's the new law about this longer term protective order available to victims of certain types of violent felons. In general, protective orders, preliminary protective orders and full protective order hearings are supposed to take precedence on the docket. I know that really depends on jurisdictions and what is happening that particular day. Anyone want to say anything else? Sherron, Nora, or Jamesa?
Yeah, they always take precedence on the docket. Now that might mean that they might get heard after other things on a given day, because the judge wants to clear out the courtroom so that the people for the protective order hearing have a little more privacy. I've seen that happen, but in terms of getting things docketed and scheduled, they always take priority, and they're always considered emergencies, even if the courts are shut down because of COVID or on an emergency only basis, they're still hearing protective orders.
Yeah, I'd agree. I've always seen that there's always a quick turnaround with these, except of course if it has to keep lingering on because of criminal charges associated, but it's usually pretty quick, and they were definitely still going during state of emergency.
Okay, I see that, I think it was Bobby that said, Bobby Muhlenberg said that it was not a priority in JNDR, but it is in general district court, which doesn't make sense to me because JDR is going to be more frequently dealing with intimate partner violence, which we know tends to be more dangerous. So that doesn't make sense to me, and seems like something we need to fix. I think at this point, I'll close this out and just say thank you to the Action Alliance for putting on these webinars. I really think these webinars, building one on top of the other, are really helpful. And I know that Ruth is going to be talking about firearms, and I'll let you take over, Laurel.
I don't think I have that much more to say other than thank you all so much for being here, and you'll get both the recording of today's session and these slides again, as well as the handouts in a follow-up email. And we hope to see you all same time next week for our last session. So thank you all so much.
Thank you, everyone. Take care.